Thank you. My name is Terry Moore, and I'm an attorney with Krugliak Wilkins, and I represent the church, the property owner in this situation, which is First Friends Church. And I'd like to address a couple of issues. And before I do that, I think I'll ask Mr. or Mike some questions, and then I'd like to reserve the opportunity to make some comments. Mike, when you executed or negotiated to execute the ground lease with First Friends, did you have several meetings with First Friends Church and their representatives?
I think you're misrepresenting my portion of the project. I'm the architect and engineer. I am not the ground lease individual associated with this.
The ground lease individuals, Jason Woodward?
I don't know who actually executed the lease. I was not a part of that project.
Were you part of the project? Were you ever on site at First Friends Church? Pardon?
Yes.
And did you have an opportunity to meet with some of the First Friends representatives?
Many of them.
How many times did you do that?
I'd say 4 to 5 times. I can't remember exactly.
Okay, 4 to 5 times you met with representatives of First Friends Church. And did they have some concerns about how you were going, where you were going to locate the tower?
This is the position that they chose. We gave them many options. This is the one they chose, and everybody agreed to.
Okay, this one here?
Yes. That size of lease area.
Oh, that size of lease area.
Correct.
Did they have a specific location for the pole?
No.
Oh, they didn't? It was anywhere. How did it,
How
was it determined that it was going to be in the middle of the lease area?
Typically, we try to put it in the middle of the lease area so that you can put your equipment around the perimeter of the pole. In this particular case, due to setback regulations, we had to offset it.
Okay, so it had nothing to do with the distance from their future expansion. Is that what you're testifying to?
No, it had something to do with the height of the structure, had something to do with it, not the position of the pole.
Okay, so the height of the structure was a concern to them?
I do believe so, but it was just in the matter of offset. They didn't necessarily care about the actual height of the structure. They wanted to make sure that the tower was set back from their future expansion.
That's correct, and they wanted to be set back 150 feet, didn't
They wanted to set back the height of the structure,
they? Okay, and the height of the structure is what now?
140 feet.
Now, is there anything on top of the structure that goes beyond the 140 feet?
Lightning rod.
So is that part of the structure?
No.
Oh, that
It's
is.
it's an appurtenance.
So it's just, it sits on top of the structure, though, correct?
Correct.
Okay, and if the tower would fall, that rod would hit the future building.
And I'm sure you heard my testimony relative to the plan failure, the design failure of the structure, so it will collapse upon itself.
Well, I've heard your testimony, but their concern when they negotiated the ground lease was they wanted the tower 150 feet away from their building. Is
They
that right?
wanted the height of the structure away from the planned future expansion.
Okay. And now you've moved the tower 10 feet closer, correct?
Correct.
Okay. You moved it closer to the fence.
Moved it 20.
Adjacent to the
Moved
fence.
it north.
Okay, adjacent to the fence on the one side instead of having it in the middle. Correct?
I think you can see that on the plan, sir.
Yes. And do you know what, are there ball fields out here?
Ball fields are to the west of the site.
Okay. Do you know if there was a concern on First Friends Church that they have over 1,000 kids and many adults playing on these ball fields, and they wanted the cell tower, the actual tower, to be in the middle so that it wouldn't be something that somebody would try to climb the fence and get up into?
I never heard that.
Okay. And now you've taken a storage shed. Was that enclosed?
It was, yes.
Was it locked?
Yes.
And now you have what looks like some people would consider to be a platform. You call it a platform. And it looks like you could climb on that, correct?
You can get out on the platform, but you can't get in the equipment, it's all locked.
Okay, but you can certainly climb on an elevated platform.
Yeah, a platform that's 2.5 feet in the air.
Yeah, much like a jungle gym. Okay. So you have these considerations. Now, here's my real question to you. You had 4 or 5 meetings with First Friends representatives prior to there being an agreement on the location of this property, correct?
I'm not sure what you're referring to as the agreement.
Well, the ground lease agreement and
That
the
was fully
specific,
executed by the time I got involved in the project.
did it not require a specific location and a specific agreement on the improvements and a survey to be subsequently attached? Did it?
The survey was shown to the church, and they agreed with that location.
That's exactly correct. Exact location of that premises and the town.
After we gave them the options associated with where they potentially would want it or where we proposed it, this was the agreed location.
Okay. And you didn't negotiate the ground lease agreement, did you?
I told you that already.
Okay. Would it surprise you if I told you that in the negotiations with Jason Woodward and other people in your company,
Not my company.
well, the company that you are an independent contractor with,
I'm not sure who you're referring to.
Tower Company,
I'm working for them as an A&E, as an architect and engineer.
okay, as a supplier.
I'm not a land lease guy, I'm not a real estate guy.
Okay, but didn't you, you were aware, or you may not have been aware, but would it surprise you if in the ground lease, specific wording was taken out so that you could not make modifications and sign our name and submit it?
I have no knowledge of anything like that. I think you're making stuff up.
No, would you like to see the draft? We
I haven't
specifically.
even portion of that, so I'm not sure why you're even asking me this question. I think you're out of line.
Okay, well, you know, you're not entitled to object. He got to ask whatever he wanted. And what is important here is we anticipated and required pursuant to the terms of the ground lease, that if you made changes or modifications, that you would come back to us. Now, we found out, my client found out about this revised site plan and survey, not before you filed the application, but after you filed the application.
There was no revised survey. All we did was reorganize things within the compound. Survey never changed.
Did the tower location change?
That has nothing to do with the survey.
Oh, is it on the survey?
No, I don't believe it is.
Yes, it is. And the shed changed, storage area changed,
Pardon me?
storage area changed, location.
The building.
Yeah,
No,
no, it's not even a building anymore, is it?
Well, but it is in the same location.
Here's my point. Why wouldn't you come back to the property owner and review this with the property owner before you submitted it as paragraph 6E requires?
You're going to have to take that up with somebody else, because you're asking me questions I had no part in it whatsoever, so.
Okay, well, I guess the question I would ask you, did you meet with representatives of First Friends Church prior to making and preparing the second application?
I do not personally know.
Do you know if any people at your company did?
Not my company, no.
Okay.
I'm the only person, so can't be anybody else.
Well, how about Tower Company? Did anybody else? Are you aware?
You have to ask them.
Would you think that's reasonable to have met with them 4 or 5 times and then unilaterally submit an application
Happens all the time.
where the property owner has negotiated provisions in the contract that do not allow you to do that?
Not allow you to do that. We should be able to do anything if they're inside this exclusive space.
I think that would be all the questions I have for Mike. But here's the position of First Friends Church. First Friends Church executed the ground lease with Calico. And we negotiated with Jason Woodward. I negotiated with Jason Woodward. And I've heard Mike speak to the issue of other property owners. When we were negotiating with Jason, we were negotiating price on a number of times. And what Jason advised me is he had multiple locations and that my request for additional compensation or increased rent was not something that was acceptable and that he could find other locations. Okay? Now that seems a little inconsistent with what Mike said here today, but Mike wasn't part of the negotiations.
I was not part of that portion of it.
He's making comments.
I'm sorry.
Limited to the questions he asked you.
But the most important thing here is that Mr. Matthews, who's a good lawyer, I know him, worked with him, he represents that this ground lease is sufficient approval of the property owner. And I submit to you that pursuant to the terms of the ground lease, Tower Co. had an obligation to come back to First Friends Church and say, we're making these modifications. Do you have any concerns? Do you have any issues? And when we found out about the application on October 15th for the first time, instead of much earlier, where they could have met with us like they did before they executed the ground lease and they prepared the first survey, we found out about it and we immediately sent a letter saying, hey, we have some concerns, we'd like to talk to you. Before I sent the letter, I called him 3 times. No return call at all. Then we sent a letter dated November 9th requesting a meeting with them so that we could address our concerns, so that, because we have an obligation under the contract to proceed in good faith. So we wanted to address our concerns and see if we could reach an agreement that would be acceptable to the property owner and to Tower Co. Never got a response back until this week. And I get a letter today responding to our letter for the first time. That's just not appropriate. What you should do if you're a company with an agreement, especially with the church, who's got thousands of kids performing on ball fields right next to them, they should talk with us. So my client may not have an objection if they had an opportunity to talk with the engineers and the architects, and we could understand exactly what's going on. But right now, we do have an objection. They don't talk to us, and we think that's inappropriate. We think they should be talking to us about this, this ground lease. We know that there are concerns from neighbors. Frankly, I think my client has requested, they didn't realize there was going to be such an outcry of concern about the tower. We understand that Tower Co., though we've asked to be let out of the lease, forego the funding and just move on. We understand that they have an agreement to proceed, and we're willing to honor that agreement. But that agreement requires that you get our consent on any site survey, right there in paragraph 16. And secondly, it requires that you use your best efforts to proceed with that original plan. And I submit to you, they've withdrawn that application. So now it's my understanding that they've withdrawn the application. That does not constitute best efforts, because they have another obligation under the contract, and that's to minimize the impact upon our property. That's an obligation that we specifically negotiated into the contract. And by ignoring us, it's just not appropriate, and my client has not consented to the filing of that site survey and to the second application. So that's not to say that we might not, but you need to talk to us. Those are the only comments that I have.
Thank you, sir.
Mr. Chairman, if I may, for the members of the commission, it's my belief that the obligations that we have in this contract are really beyond the expected review of this commission. What was initially provided to you was a summary of the contract, and that was what's recorded, and basically that tells you that there's an agreement, permission to place this based on the site plan and so forth, that the appropriate place for this type of review, the viability of this contract, is better suited in our common police court. And that is available to First Friends Church if they wish to object to this contract and each other's obligations. And that may be done through a request for an injunction and a request for a declaratory judgment, asking our local court to take this under review. And the injunction would be that during that time, that the whatever decision may be made based on the viability of that contract would be stayed pending the decision of the court. So my recommendation would be to simply take it at its face value of what you received, the summary of that, and if there may or may not be this request for this injunction and declaratory judgment, and if that doesn't occur, then there's nothing that prevents moving forward based on what you understand as there's an agreement between First Friends and Tower Code to place the tower at that location.
Mr. Chairman, I want to clarify something before we proceed, make sure that there's no conflict. In the ground lease agreement, it was brought to my attention, and you got there before I did sign the original deed for that piece of ground. I did a survey on it. That was before the church owned it. I do not believe I have a conflict there, so I'm going to proceed as if
I would agree. I could see, what's the date on that?
1996.
1996. I have to believe you'd have no idea that something this magnitude would occur and it would influence your decision to sign that document. But thank you for raising that for anyone that would see it.
Thank you.
Just to confirm or make sure it's clear in my mind, Mr. Fox, so you're saying that as a planning commission, we have a proper authority from the landowner to proceed if we so choose?
It appears so based on the summary of that contract that was recorded. Yes, sir.
Thank you.
Mr. Chairman, I could say that most jurisdictions, and I haven't read the North Canton jurisdiction, but most jurisdictions require the lessee, the agent, to sign the application as well as the property owner to make sure this issue does not come up. Because if the lessee, they have no interest in the premises that's been established by their unilateral documentation. What interest do they have? They have none. It's got to be established pursuant to the lease agreement. And most jurisdictions, including, I know Jackson Township, requires both signatures.